Lawton Chiles, one of the greatest governors of Florida, stated, "I didn't come to stay, I came to make a difference." Well, he did make a difference, and after surviving divorce, I too want to make a difference when dealing with custody for fathers and custody for mothers. Hi, my name is Matthew Brickman, president of iMediate, Inc. This month I want to talk to you about family mediation in general, custody, and child support. I am an exit strategy professional. What this means is that I can help you exit your situation with the goal of saving you time and money while preserving what relationship you have left so you can successfully co-parent separately. I mentioned that I want to make a difference when dealing with custody for fathers and custody for mothers. While we don't use the term custody in Florida any longer due to the fact that the only people that get taken into custody are criminals and they're the only ones with visitation rights, I will use this term interchangeably because it is a term that is most understood outside of the judicial system. We actually use the term timesharing instead of custody. While most people are familiar with terms like sole custody, which means that one parent has all the time sharing and the other parent has no time sharing, or joint custody where the parents share time, I may use these terms interchangeably, again, only for clarity purposes. Divorce for me was very difficult and trying. It was my darkest day as I felt like a failure, and over the past 13 years of being a mediator, I know that divorce too feels like that for many of you. Divorce for kids can seem very scary as well. For the parents and the kids, it is truly a time of uncertainty, and my job as a mediator is to help empower you to create a new and better tomorrow, which in turn will create stability and a new beginning for your kids and your family. So let's talk about custody and child support, which are the two most important things to people usually in a divorce. In any custody court hearing, people assume a lot, and after speaking with friends and neighbors and coworkers who have gone through divorce, many have a lot of incorrect assumptions. Many people wonder how the law may apply to their situation regarding time sharing or custody, as well as what will the joint custody child support come out to be. Lots of assumptions are made that if we have equal joint custody, then there will be no child support. Well, there are many factors unique to each case that have to be accounted for before this assumption can be correct. And there are two places to find out the truth about what your particular child support will be. The first is by consulting an attorney and having him or her run your child support calculation. The second is that if the two parties choose not to hire an attorney and simply come to a mediator to help them create their final agreement, parenting plan, and run their child support numbers and save thousands of dollars in the process, then the mediator will run that calculation based on the agreements of the parties. The child support is a statutory calculation and has to be run by a professional who has a software or computer program to do so. When it comes to time sharing or custody, what I see most in South Florida cases is equal, or at least very close to equal time sharing being ordered by the court. This has become the norm since 2011. Now, while the statute does not say that there is a premise or a presumption for 50-50 yet, the statute does say that children shall have frequent and continuing contact with both parents, and thus most courts have been very close, if not exactly equal, when it comes to custody or time sharing. When filing for divorce, some people file for an emergency hearing. Most courts no longer grant emergency hearings, as very little is considered an emergency to the court. While your life and situation may feel like an emergency to you, again, most courts do not grant emergency hearings. But to see if your case may be considered an emergency, you need to consult legal counsel for that advice. Once you file for divorce, if not considered an emergency, before you are in front of a judge, and in some cases before you even get assigned a date to go in front of the judge, you will have to attend mediation at least one time, if not twice, to try to settle your case before having the court decide your life. Okay, so let's go back to child support. Child support usually is a hot topic in mediation because it takes money to raise kids. And so one parent is usually trying to pay as little as possible and trying to get as much time sharing or custody as possible. And the other parent is usually trying to prohibit time sharing or custody as to get as much child support as possible. While this is an awful practice, since kids are not pawns and not to be bought or sold, some people still do view kids this way. Try to keep custody or time sharing separate from child support, as the court views them as separate issues, even though one creates the other, meaning child support cannot be created without a time sharing schedule. When it comes to having to pay for child support, some people try to figure out how to beat child support when filling out their own financial affidavit, which can be considered child support fraud. Now, don't be afraid, because the financial affidavits have to be proven by supporting documents. The documents that we use are either pay stubs, tax returns, bank statements, and such. So you can't just write down whatever you want and hope that this is going to be believed without supporting documents. So be truthful when filling out your affidavit, because the supporting documents don't lie and the numbers will be based on your documents, not just what you write down. The potential fraud, whether intentional or not, will all get sorted out either way in mediation with your mediator or in the discovery process with your attorney. When it comes to how to stop child support or how to be taken or get off child support, the statute outlines how this will be placed, or how this will take place. In Florida, child support ends when a child emancipates. So emancipation is when the child turns 18, marries, dies, otherwise becomes self-supporting, or if the child is between the ages of 18 and 19, still in high school, performing in good faith with a reasonable expectation of graduation before age of 19, then child support will continue until the child graduates from high school. To get taken off of child support all depends if you have been put on child support. So it depends on the method chosen by the parties for child support to be paid. If paid through the state of Florida or the Department of Revenue, then you will get off of child support when child support ends according to the court order, which instructs the department to take you off. If the parties elect not to pay through the state, but simply pay direct, then no one actually gets taken off of child support because nobody technically got put on child support. Child support would end when the statute and the parties' agreements say it ends, as I just explained. One side note, though, with regards to child support, the court has extremely limited power to deviate from the statutory guideline, but in mediation and only in mediation, you as the parents have the power to completely negotiate the support, trade it for other things that may not be considered for support by the statute. Also, the court usually mandates that child support be paid through the state, but in mediation, the parties can decide to pay direct if they want. For more information about my services and to have me help you exit your current situation, call me toll-free at 877-822-1479. Call me local or text me at 561-262-9121. You can email me at mbrickman@ichatmediation.com or visit me online at iMediateinc.com.